The European Union's Digital Services Act is a superstitious crusade against free speech worthy of the Middle Ages. It is an Inquisition, armed with an industrial censorship complex. That is a serious charge. It therefore requires a serious examination. In my last video, I demonstrated that the purpose of the Swiss Digital Services Act is to censor legal content. It censors allegedly illegal content, which is legal content by definition. Now we must look at the source of the problem, because the Swiss Federal Council did not invent the Swiss DSA out of thin air. It built it on a pre-existing model. That model is the European Union's Digital Services Act. So, the following question arises. Does the European Union's Digital Services Act serve the same purpose? Is it also designed to censor legal content? Put differently, does the DSA of the EU also censor only legal content and nothing but legal content? My name is Andreas Seemann, and I am the Managing Director of the Swiss-based Alliance for Free Speech, Bündnis Redefreiheit in German, which protects free speech in Switzerland and in Germany. And today I am presenting my understanding of the Digital Services Act as such. Let us begin our analysis. To avoid confusion, I will make a simple distinction. When I refer to the original European Union Digital Services Act, I will call it the DSA or the EU's DSA. This will separate it clearly from the Swiss version. The Swiss DSA censors allegedly illegal content. But what does the DSA censor? According to the European Union itself, the DSA targets illegal content, hate speech, and disinformation. Leave aside hate speech and disinformation for the moment. What remains is illegal content without the qualifier allegedly. If you consult other sources, you see the same description repeated again and again. The stated purpose of the DSA is to tackle or censor illegal content. But what do advocates of free speech say? Let us focus on one free speech thinker in particular, a man who is known for thinking carefully about censorship in Europe, Jacob M. Changama. Jacob M. Changama is the founder and executive director of the think tank The Future of Free Speech and a research fellow at Vanderbilt University. He is well known in free speech circles that oppose censorship. So let us look at what his think tank says. The Future of Free Speech released a study in 2024 of deleted or removed content under the DSA. The study is called, and it's formulated as a question, quote, "Preventing torrents of hate or stifling free expression," end quote. All right. This seems like a serious, pro-free speech analysis of how the DSA operates. And this study by the Future of Free Speech states that the purpose of the DSA is to tackle illegal content. Okay. On the face of it, therefore, the Swiss DSA and the EU's DSA appear different. The Swiss DSA censors allegedly illegal content. The DSA, however, claims to censor illegal content without the qualifier allegedly. That seems like a clear-cut distinction, a decisive difference. But not so fast. Let us proceed carefully. The Enlightenment taught us to think for ourselves, so let us do precisely that. If you read the text of the DSA, you will see that it repeats the term illegal content again and again, roughly 100 times. At first glance, this seems to confirm the claim that the DSA targets illegal content without the qualifier allegedly. But now let us search for the phrase allegedly illegal. You will find that the DSA also refers to allegedly illegal content. It speaks of allegedly illegal content, of alleged illegality, and of illegal content as alleged. The language of the allegedly illegal is there in plain sight. So, what does this mean? Does the European Union's DSA expect platforms like Facebook to censor illegal content or allegedly illegal content? The answer is straightforward. What the DSA calls illegal content is in practice nothing but allegedly illegal content. Consider how this works. When Facebook removes your post under the DSA in the EU, Facebook will say that your content, which it has removed, is illegal content. It will cite the DSA's command to tackle illegal content as a justification and claim it is complying with the DSA. Now, recall the basic principle we established when discussing the Swiss DSA. That principle is, everything is legal until a court or judge has declared it to be illegal. This is a fundamental principle of our justice system in Europe and the Enlightenment tradition from which it springs. What follows from this is obvious. A post does not become illegal just because a private company says that it is illegal. It becomes illegal only when a judge rules that it is illegal. When Facebook removes your post in the EU under the DSA, no judge has ruled it to be illegal. The content remains legal. Yet Facebook calls it illegal content and claims it is enforcing the law by censoring it under the DSA. So, the claim that the DSA censors illegal content is false. It is a lie which the EU wants you to believe. Yes, they are lying to you, but strip away the label of illegal and the emperor has no clothes. The DSA functions no differently from the Swiss DSA. When Facebook calls your post illegal in the EU and removes it, it is making an allegation. The post is allegedly illegal and nothing more. But an allegation is not a verdict. Nonetheless, the company is asserting illegality without a judicial ruling. The difference between the Swiss DSA and the DSA collapses in practice. The EU uses the word illegal when it actually means allegedly illegal. The Swiss DSA, to its credit, is at least honest and explicit. It states openly that an allegation of illegality is enough to trigger removal of legal content. The EU achieves the same result, but it deviously conceals the mechanism. It calls content illegal before any court has said that it is illegal. Legal speech is being censored in the name of the law that cannot forbid that which is allowed. So, we can imagine the DSA has 4 crucial levels of content: legal content, allegedly illegal content, illegal content without the qualifier allegedly, hate speech and disinformation. What the EU's DSA calls allegedly illegal content is quite obviously allegedly illegal content. What the DSA calls illegal content is also just allegedly illegal content. The same goes for hate speech and disinformation. Hate speech and disinformation are concretized forms of allegedly illegal content. Hate speech and disinformation consist of legal content that a social media giant claims is illegal. We can therefore stop asking the question, constantly asking the question, who defines what hate speech is? Who defines hate speech and disinformation? This is a good question, but somewhat beside the point. The point is, hate speech and disinformation are forms of allegedly illegal content, and allegedly illegal content is legal content, until a court rules otherwise. We now have a precise definition of hate speech and disinformation. It is simply legal content. The DSA thusly suffers from the exact same defects as the Swiss DSA. The phrase illegal content suggests that the standard for judging something to be illegal is the law, especially the criminal law. In practice, this is totalitarian. The law defining what is forbidden is invoked to suppress that which is allowed and legal. The forbidden is used as a pretext to forbid that which is allowed. If Facebook removes your post in the EU, you have two choices. You accept the censorship, or you take Facebook to court. If you go to court, you are initiating a civil proceeding, a civil litigation. The civil judge in the civil proceeding has no authority to declare your post illegal under criminal law. The judge will not even rule that your post is illegal under civil law. The court will not determine whether your post is illegal in any definitive legal sense. The judge will only decide whether Facebook's allegation of illegality was reasonable and justified. So, the judge in the civil proceeding is not asked to decide whether the censored post is actually illegal. The civil judge is asked instead whether Facebook was right to consider the censored post to be potentially illegal. That means the user has no reasonable chance of winning the court case against Facebook. As with the Swiss DSA, the censored user in the EU cannot argue in court that his legal post is legal. He cannot argue that his legal post is not illegal, he cannot argue that his legal post is allegedly legal, and he cannot refute Facebook's allegation that his post is potentially illegal. If we compare it to chess, then the user begins in check and ends in checkmate. What does it even mean when the DSA commands Facebook to censor illegal content? The DSA pretends as if illegal content exists in and of itself. It treats illegal content as though it exists independently of a court ruling. Let us consider this assumption. If content is treated as illegal before a judge has ruled it to be illegal, then no judge is needed to confirm its illegality. A judicial decision would add nothing. It would merely repeat what has already been assumed and presupposed. If it's already illegal to begin with, you don't need a judge to tell you it's illegal anymore. When platforms declare illegality, courts become unnecessary. If Facebook calls your post illegal under the DSA, then a judge confirming it to be illegal would be useless repetition. It would simply echo what has already been presupposed. If something is declared illegal at the outset, the courtroom becomes redundant because the verdict has been issued in advance. This means the EU proceeds as if something can be illegal without a court judgment. Let's think that through. If illegal content can exist independently of a court judgment, then by reductio ad absurdum, allegedly illegal content can exist without an alleger. That's obviously insane. But that is exactly what the Swiss DSA expects us all to believe. Under the Swiss DSA, users are invited to report allegedly illegal content to Facebook. But how can a user find allegedly illegal content to report before anyone has alleged anything? Content becomes allegedly illegal only once an allegation is made. So the user, who claims to have discovered allegedly illegal content, is supplying the want of an allegation himself. This is cheating, to say the least. The accusation is smuggled in under the pretense of discovery. The content is not allegedly illegal in and of itself. It is simply legal content. The allegation is what transforms it from legal content into allegedly illegal content. And when Facebook is then asked to determine whether the reported post is allegedly illegal, the user's allegation has already settled the matter. The question answers itself. The user's allegation delivers the conclusion. The same mistake is made when the DSA speaks of illegal content. Let us be clear. Neither illegal content nor allegedly illegal content exist as a legal fact without a court ruling or at least an identifiable accuser or alleger. Without that, these terms are mere abstractions. These things do not exist as such. This is a philosophical mistake masquerading as regulation. It treats abstractions as realities. It speaks of illegal content as if it were a Platonic form or a Platonic idea floating above the legal system, existing independently of courts and judgments. These things do not exist. Therefore, the DSA and the Swiss DSA cannot be implemented. Look, I could make a law that commands all witches to be burned at the stake. If you're thinking rationally, you know witches do not exist. Hence, the law cannot be implemented because the object it outlaws is imaginary and does not exist. But if you believe in witches, you will find plenty to burn. And that is exactly what the Swiss DSA and the EU's DSA are. They are witch hunts dressed up as a regulation. The target is hate speech and disinformation. The witches they hunt are the very legal posts which the EU hates. They will chase these witches across borders, across jurisdictions, across the Atlantic if necessary. No distance is too great to purify the internet of legal posts that question the EU's flimsy authority. This is censorship with missionary zeal. It is totalitarian in instinct, unlimited in scope, and downright superstitious. And recall how the user cannot defend himself in court. Recall how the allegation that a post is potentially illegal cannot be refuted. Yes, the great thing about a witch is that she cannot defend herself. The DSA operates like a medieval witch trial, a drowning test for witches. If the alleged witch sank, she was innocent, but also dead. If she floated, she was guilty and condemned, and probably then also dead. The test was designed so that the woman could not win. That is how the fiction of illegal content works under the DSA. Your speech is labeled illegal before any court rules it to be illegal. If the user accepts the censorship, his free speech is permanently suppressed without his own protest. If the user challenges the censorship, the question before the civil judge in the civil proceeding is only whether the allegation against you was reasonable. Since the allegation is irrefutable, it must be reasonable. Like the witch, the user is trapped in an insane fantasy built to defeat him. Sink or float, the user loses. So, we come to this conclusion. The DSA's purpose is to censor legal content. It cannot censor illegal content because illegal content requires a court ruling. What it actually censors is speech that remains legal. It censors legal content and nothing but legal content. The DSA simply pretends that legal content is illegal content. That is my understanding of the EU's DSA and of the DSA as such. The data confirms it. The 2024 study on the DSA's censorship, conducted by the Future of Free Speech, led by Jacob M. Changama, found that between 87.5% and 99.7% of the deleted comments they analyzed were legal or legally permissible. That's almost 100%. When it comes to the DSA, the deletion and censorship of legal content is a feature, not a bug. Censoring legal content is the purpose, not a mistake. So, the hypothesis that the DSA exists to censor legal content fits the evidence. The facts line up with the hypothesis. And in any serious inquiry, the theory must be made to fit the facts, not the other way around. Which raises an obvious question. Why does Jacob M. Changama and his organization begin from the premise that the DSA's purpose is to tackle illegal content? That is the next question we must answer. Because once you abandon M. Changama's premise, once you abandon that premise, that the DSA exists to censor illegal content, the entire mainstream evaluation of the DSA changes, quite radically and fundamentally. In the next video on our DSA series, we will examine M. Changama's bogus study in detail. So keep your eyes peeled for that. That was me, Andreas Seaman, for the Alliance for Free Speech, called Bündnis Redefreiheit in German. Over and out.